Welcome to today's deep dive. We are really thrilled you are joining us today because our mission is a truly fascinating one.
It really is. It's a heavy one, but a fascinating one.
Yeah, we are unpacking this really dense, thought-provoking academic review essay that was published in the Journal of Legal Anthropology back in 2010.
Right, by J.P. Linstroth.
Exactly, J.P. Linstroth. And the essay is titled Maddening Legalities, Subjectivities, and the Law.
Which is such a great title.
It is. Because what Linstroth does here is review two very distinct books to explore this really powerful collision. What happens when the rigid black and white world of the law violently crashes into messy, complex human psychology?
Right, or to use the term that anthropologists prefer, human subjectivities.
Subjectivities, exactly, is a profound collision to examine. But before we get into the mechanics of that, we do need to offer a mandatory and very explicit disclaimer to you, the listener.
Yes, this is important.
Today's source material deals with highly politically charged topics. Specifically, we'll be discussing the 9/11 terror attacks, al-Qaeda, and the Israeli-Palestinian conflict.
And we want to make it unequivocally clear that neither of us is taking any political sides today.
None at all.
Our goal is strictly to impartially report on the content and the ideas presented in Linstroth's essay. We're here solely to explore the socio-legal concepts contained within that original source material.
Right. I appreciate you setting that boundary. It's crucial. So, diving right into this, the central theme of Linstroth's review really hinges on that word, subjectivity.
What's fascinating here is this core concept of subjective dynamics. That's a term actually coined by the late anthropologist Begonia Aretxaga.
Subjective dynamics.
Yeah. You see, the law as an institution often pretends to be completely objective, right? It presents itself as this neutral arbiter of truth, operating totally above human emotion.
Like a machine. Just input the facts, output the justice.
Exactly like a machine. But Aretxaga and Linstroth, by extension, argue that the reality of the state and the law is shaped by deep human desires, severe fears, and deeply unequal power dynamics.
It's run by humans, after all.
Right. It is a system reacting to and very often failing to comprehend the complex emotional and psychological realities of the people who are actually moving through it.
I want you, the listener, to think about a time when you had to deal with a massive, faceless bureaucracy.
Well, we've all been there.
Maybe it was a really complicated tax issue or trying to get a convoluted medical claim approved. Remember that feeling when the system completely ignored the nuances of your personal situation?
It's maddening.
It is. You're sitting there on the phone trying to explain the context, the why behind what happened, and the system just says, does not compute. Box not checked.
Yeah, the computer says no.
Exactly. That frustrating friction is exactly what we're looking at today, but scaled up to a massive global and sometimes very violent level.
Because the law wants a checked box. But a human being is a web of motivations, traumas, and beliefs. And that brings us to the first of the two books Linstroth reviews in his essay.
Okay, let's unpack this. The first book is Catherine Donahue's 2007 ethnography titled Slave of a Law, Zacarias Moussaoui versus the USA.
Right.
The subject here is Zacarias Moussaoui, who was the very first terror suspect tried for complicity in the catastrophic events of September 11, 2001.
A massively high-profile case.
Unbelievably high profile. And Donahue's book details the wild dynamics of this trial, which dragged on from 2001 all the way to 2006, eventually ending in a life sentence conviction.
I mean, the trial was a total media circus.
It's on the news every night. But what was actually happening behind the scenes legally?
Well, Donahue chronicles how the trial process itself became a stage for this clash between rigid legal protocol and extreme subjective reality.
How so?
For instance, there were intense arguments over whether the death penalty could even be applied. At one point, the judge actually ruled to forfeit the death penalty entirely.
Wait, really? In a terrorism trial?
Yes, because the prosecution team flat out refused to produce certain witnesses, citing national security concerns.
Wow.
The judge even threatened to dismiss the trial entirely because of how the case was being handled, though that death penalty forfeiture was later reversed.
But I remember the most staggering part of the trial dynamics had to be Moussaoui himself. He made the shocking decision to represent himself as his own legal counsel, didn't he?
He did. He requested to proceed pro se.
Pro se, yeah.
Yeah. For those unfamiliar with the legal terminology, proceeding pro se means you waive your right to a defense attorney and you advocate for yourself.
Which, in a federal terrorism trial,
is virtually unheard of because of the sheer complexity of the law. But Moussaoui insisted...
actually gave a statement to the court about this, right?
Yes. In his statement to the court, he said, In the name of Allah, I take the control of my defense to mount a significant defense of the life that Allah, the most masterful, has granted me.
I mean, when you hear a statement like that, it feels like he isn't even speaking the same language as the court.
He really isn't.
How does a federal judge manage a defendant who is operating on such a vastly different wavelength?
Well, that is exactly what Linstroth means by maddening legalities. If we analyze Moussaouy's behavior throughout the trial, we see a man who is using the American justice system as a platform to wage his own personal jihad.
So he's treating the courtroom like a battlefield.
Precisely. His filings and spoken words were contradictory, inflammatory, and actively abusive toward the court.
He was trying to break the system.
He was intentionally provoking it. This
Yeah.
is a prime example of a kind of subjective madness coming into direct abrasive contact with a highly structured, rigid legal framework.
I can't imagine being the judge in that room.
The judge in the case, Federal District Judge Leonie Brigema, had to exercise remarkable tolerance for his outbursts, just to keep the wheels of the legal process turning at all.
Which makes you wonder, and I know Donahue explores this in the second half of her book, how someone arrives at that point in the first place.
Right, the path to radicalization.
Exactly. How does someone develop a subjective reality that allows them to orchestrate mass terror?
I think the common assumption for a lot of people might be a profile of extreme poverty or just a total lack of education.
But the source material offers some surprising facts that challenge those assumptions entirely.
He wasn't uneducated, was he?
Not at all. Moussaoui was not uneducated, nor is he destitute. He actually held a master's degree in international business from London.
A master's in international business. So if it wasn't a lack of education or extreme poverty, what was the catalyst here?
The background Donahue paints is complex. Moussaoui is of Moroccan heritage, and he grew up in France. And like many immigrant families there, he faced systemic racism and intense social exclusion.
So he felt totally locked out of society. The stigmatization in French society was severe. It's within that context of feeling blocked and alienated that he eventually converted to radical Islam and adopted the extreme political ideologies of al-Qaeda.
And he really committed to it.
He did. Evidence showed he followed the exact profile of the other 9/11 hijackers. He was attending flight school, buying knives, working out at gyms, receiving overseas remittances, and traveling to Afghanistan, Pakistan, and Malaysia.
To meet with the leadership.
Yes, to meet with Osama bin Laden and Khalid Sheikh Mohammed.
But the racism and social alienation he faced in France, that can only be a partial explanation, right? I mean, millions of people face terrible exclusion and systemic racism, and they do not choose to become terrorists.
And Donahue pushes that exact point. Social alienation is only a piece of the puzzle. Moussaoui's experience of exclusion was particular to him, yes, but ultimately he chose that path.
He had agency.
Exactly. His decision to leave France and join al-Qaeda cannot simply be reduced to a lack of opportunity or a dreary life in the French suburbs. And this is where the law struggles so mightily.
Because the law wants to put him in a neat little box.
Exactly. When prosecuting him, how does the justice system categorize his subjectivity? Is he simply an evildoer? Is he crazy, delusional, and psychotic? Or is he a structural product of his environment?
It's probably a messy mix of all of the above.
But the law requires a neat categorization to assign culpability. Moussaoui's subjective reality bleeds across all those lines. He aspired to commit mass terror, which, as the essay notes by referencing another scholar, Joseba Zuleika, is in and of itself a kind of madness.
But Linstroth doesn't just blindly praise Donahue's book, though. He offers some pretty sharp academic critiques of her approach.
He does. Linstroth felt that Donahue relied a bit too heavily on the theories of Pierre Bourdieu to explain the structural violence and racism in France.
Bourdieu. His theories often focus heavily on how social classes and environments reproduce certain behaviors, right? Essentially suggesting people are conditioned by their surroundings.
Right, the idea of habitus. But Linstroth points out that by leaning so hard on Bourdieu, Donahue missed a valuable opportunity to engage with other prominent scholars of violence and subjectivity.
Like who?
Like Paul Farmer or Arthur Kleinman, who focus more deeply on the physical and psychological toll of structural violence and human suffering.
He also brings up Mahmoud Mamdani, right? The author of Good Muslim, Bad Muslim.
Yes, Mamdani's work is crucial here because it looks at the actual political ideology and agency behind modern terrorism, rather than just treating it as a passive byproduct of social exclusion.
So treating them as political actors, not just victims of their environment.
Exactly. Linstroth suggests that engaging with Mamdani's ideas would have significantly deepened Donahue's analysis of political Islam and al-Qaeda propaganda.
He also draws a contrast between Donahue's book and Susan Hirsch's 2006 book, In the Moment of Greatest Calamity.
Yes, Hirsch's book is a much more personal account. She's an anthropologist who actually survived the 1998 U.S. embassy bombing in Africa.
And Dar es Salaam.
Right. Linstroth feels Hirsch's work grapples with the larger questions of justice and terrorism in a richer, more encompassing manner than Donahue's reliance on just court documents.
Which brings up a really fascinating methodological point about Donahue's work.
Yeah.
Because she didn't actually interview Moussaoui.
No, she couldn't.
For practical and security reasons, obviously. An academic isn't going to get government clearance to casually interview a high-level terror suspect in maximum security.
Exactly. So her ethnography is built largely on court transcripts and official documentation.
Which is kind of amazing when you think about it.
It is a profound takeaway for anthropology and legal studies. It proves that you can still do meaningful socio-legal analysis, what the essay refers to as studying violence from a distance.
Even when your subject is locked away in Supermax.
Yes. By analyzing how Moussaoui represents himself in court documents, you can still map out the clash between his subjectivity and the state's legal apparatus.
Here's where it gets really interesting. Linstroth pivots the essay from this spectacular high-profile terror trial in a U.S. federal court to something that feels entirely different.
The mundane.
Yes, the mundane, grinding daily life on the borderlands between Israel and the West Bank. This brings us to the second book he reviews, which is Tobias Kelly's 2006 ethnography, Law, Violence, and Sovereignty Among West Bank Palestinians.
And methodologically, this book is the exact opposite of Donahue's distance study.
He was right in the thick of it.
Very much so. Kelly took a highly traditional, immersive ethnographic approach. He spent 2 full years in the field, including 18 months living in a West Bank town.
He uses a pseudonym for the town, right? Beit Hajar?
Yes, Beit Hajar. And he was there during a remarkably tense period. It was during the violent upheaval of the Second Intifada, right as the promises of the Oslo Accords were collapsing.
You might think a book about the West Bank during the Second Intifada would just be wall-to-wall accounts of spectacular violence.
Right, that's what you see on the news.
Exactly.
Yeah.
But Kelly shares a really surprising insight. While the threat of violence is always there, life in the West Bank is actually dominated by what he calls the tedium of bureaucratic practices.
Tedium.
Yeah. The everyday conflict isn't just about armed clashes. It is a grinding, endless conflict over legal rights and paperwork.
It is the ultimate manifestation of maddening legalities. Kelly identifies how the collapse of the Oslo Accords created a system where the law was supposedly meant to separate Israelis and Palestinians into neat, legal, and political frameworks.
But in reality,
it just created a fragmented nightmare. To make this concrete for you listening, Kelly details a highly specific, memorable example of an employment dispute in the village of Beit Hajar involving 2 men, Khalid and Marwan.
right. Khalid is a Palestinian day laborer, and Marwan is a Palestinian mediating contractor from the same village.
Yes.
They're doing contracted labor for an Israeli employer. The work gets done, but the Israeli contractor simply fails to pay them.
A classic wage theft scenario.
Exactly. So they want their money. What are their legal options in this fragmented system?
Well, in a functioning legal system, this is a simple breach of contract. You file a lawsuit, go to civil court, and get your back pay.
Easy enough.
But for Khalid and Marwan, the legal pathways are a labyrinth of impossibilities. This is where the subjective reality of the Palestinian worker hits the brick wall of the border regime's legalities.
Let's break that down. First, they can't just use their local courts, can they?
No, they cannot use the local Palestinian Sharia courts in Ramallah.
Because those courts have very specific jurisdictional limits under the Oslo framework.
Precisely. The local courts in Ramallah are largely restricted to handling personal status issues, things like marriage, divorce, and inheritance.
So a business dispute is out of the question.
They have absolutely no jurisdiction over cross-border business and employment disputes.
So if the local courts are a dead end, their only legal recourse is to take their claim to the Israeli civil courts.
Which requires a Palestinian employee to physically cross into Israeli territory.
And that is not a simple commute.
Not at all. That means navigating Israeli military checkpoints. As Kelly points out, legal status in this region is always a spatial practice.
A spatial practice, meaning your rights depend on where you are physically standing.
Yes. Your rights literally depend on where you are standing and whether you have the exact, unpredictable documentation required to pass a military checkpoint that specific day.
So we're talking about trying to secure unpaid wages by repeatedly putting yourself in a potentially dangerous situation.
Think about the sensory and psychological reality of that checkpoint, the waiting, the interrogations, the sheer uncertainty of whether your permit will even be recognized.
Just to file some paperwork.
Just to file it. Pursuing a civil case in an Israeli court could take years of this repeated trauma with no guarantee of success. Some villagers even resorted to obtaining illegal driver licenses or holding onto foreign passports just to bypass these barriers.
And Kelly points out the bitter irony of it all. He notes that the Israeli settlements heavily depend on Palestinian labor to function.
They rely on them.
Israeli courts even apply Palestinian national authority law in certain contexts. But the legal system fundamentally relies on creating what he calls non-spaces, non-citizens and non-rights, for the exact West Bank Palestinians doing the labor.
It's a paradox. The space of citizenship for one group entirely depends on the legal void created for the other. It is systemic exploitation woven directly into the bureaucratic fabric.
You are promised the protection of the law, but your access to it is entirely mediated by a security border that views you as a threat.
Exactly. And we see another fascinating example of local bureaucracy failing the people in Kelly's account of the late 1990s teachers' strike.
Oh, the HCCT strike.
Yes.
The Higher Coordinating Committee for Teachers.
Yeah.
They go on strike against the Palestinian National Authority, the PNA.
Right.
They are striking over the implementation of a civil service law. The core of the dispute was that teachers with years of experience were demanding higher pay than the newly minted bureaucrats working for the PNA.
And here is where the subjective dynamics paralyzed the institution itself. The PNA was trapped in a paradox of its own sovereignty.
You might ask, why wouldn't the PNA just enforce the civil service law and pay the experienced teachers? It seems fair.
Kelly explains that the law wasn't applied fairly because enforcing it would have disadvantaged the very political elites and bureaucrats who were in charge of the PNA.
So the PNA was essentially a fledgling institution. If they alienated their own bureaucrats, they risked total collapse.
They were caught between acting like a state and surviving as a political faction.
That's a tough spot.
Kelly notes that the villagers of Beit Hajar were totally uncertain about how to even view the PNA. On one hand, it had the manifestations of statehood, so people expected it to act like a fully functioning, accountable sovereign state with real bureaucratic rationalism.
But the reality on the ground was quite different.
Vastly different. It was widely viewed as a weak, corrupt interim authority. It couldn't enforce its own civil laws without leaning on local power brokers, patronage networks, or groups rooted in armed mobilization.
And didn't the teachers end up giving up on the strike?
They did. The teachers ended up supporting the PNA when it put down their own civil service strike.
They supported their own suppression.
Yes. They knew the institution was terribly weak, but they accepted the suppression because the alternative was total chaos.
It shows how legal authority isn't just a document. It's a performance. And when the performance fails, the subjective reality of the people living under it is one of profound instability and fear.
The rules on paper meant absolutely nothing compared to the complex web of loyalties, fears, and power dynamics governing the streets of Beit Hajar.
So what does this all mean? We've looked at the trial of an al-Qaeda terrorist who wanted to orchestrate mass murder. And we've looked at the daily struggles of unpaid Palestinian day laborers trying to navigate military checkpoints and fractured local governments.
Two very different worlds.
If we connect the dots between these two vastly different books, what is Linstroth's ultimate takeaway?
The core insight, the real aha moment here, is that both of these books vividly highlight how legal systems fundamentally break down when they fail to account for the human experience.
When they ignore the subjectivity.
Exactly. When the law ignores the subjectivity of the people involved, it becomes maddening. Linstroth states this beautifully in his conclusion. He writes that understanding the subjectivities of terror suspects, their alienation, their specific psychological pathways to radicalization, actually helps us create better counterterrorism measures.
Because you're treating them as humans with motivations, not just faceless threats.
Right. And by the same token, truly analyzing and comprehending the subjective, everyday views of Palestinians, their frustrations with checkpoints, their economic exploitation, is essential if there is ever to be a hope of easing regional conflict.
The subjective person is what makes the study of law actually valuable.
That's the thesis.
I want to connect this directly back to you listening right now. Obviously, you might not be dealing with global counterterrorism or international border disputes in your day-to-day life.
Hopefully not.
But think about whenever you are trying to solve a complex human problem. Maybe it's managing a difficult team at work, navigating a messy family dynamic, or trying to resolve a dispute in your neighborhood.
Just laying down the rules is never enough.
It's never enough. Pointing to a policy manual is not going to solve a human problem. If you don't understand the subjective reality, the unspoken desires, the hidden fears, the perceived realities of the people involved, your rules are just going to create more friction.
You have to understand the human being before you can effectively apply the rule.
Exactly.
And if we connect this to the bigger picture, it reminds us that our institutions are only as strong as their capacity for human empathy and understanding. When the law becomes totally detached from the lived experience of the people it governs, it ceases to be justice. It simply becomes a mechanism of control.
What a journey. To summarize our deep dive today, we have traveled from the maddening legalities and spectacular theatricality of global terrorism trials in a U.S. courtroom, all the way to the tense, painfully bureaucratic borderlands of the West Bank.
We covered a lot of ground.
We did. And through Linstroth's brilliant synthesis of Donahue and Kelly's work, we've learned that the law is never, ever just black and white. It is colored by the messy, unpredictable, and entirely subjective reality of what it means to be human.
And this raises a really important question to mull over, building on everything we've discussed today regarding subjectivity and the law.
I'd love to hear it.
Well, we spent the last few minutes seeing just how deeply our human courts, our human judges, and our human-run bureaucracies struggle to understand subjective human experiences.
They fail all the time.
Right. They fail to grasp the specific alienations of a radicalized student in France, or the complex, fearful reasons a laborer takes a risk at a checkpoint in the West Bank. Now, I want you to imagine the near future.
Okay.
We are rapidly entering an era where artificial intelligence and automated algorithms are increasingly being used to process legal claims, approve or deny visas, or even flag individuals as security threats.
Oh, that is a terrifying thought.
If our most sophisticated, highly trained human institutions already fail so spectacularly to grasp these subjective dynamics, how will a machine ever understand the messy, nuanced reality of a human life?
A machine definitely doesn't care about context.
It doesn't. So what essential part of justice gets permanently lost when the law becomes entirely automated?
That is a chilling and incredibly necessary question to ponder as we move forward. Thank you so much for joining us on this deep dive today. We hope it gave you some powerful new lenses through which to view the systems, the rules, and the people around you. Keep questioning the bureaucracies in your life, keep seeking to understand the subjective realities of others, and we will catch you on the next deep dives.